Good morning, students. I'm Dr. D. Anita Kumari, Associate Professor of School of Management Studies, Wales Institute of Science and Technology, Chennai. In today's class, we are going to discuss about Transfer of Ownership and Property Act 1930, as well as the Performance of Contract Act. So in this topic, we are going to discuss the following concept. Properties that cannot be transferred under the Transfer of Property Act, responsibility of the seller during the transfer of property under the Transfer of Property Act, duties of the buyer during the transfer of property under the Transfer of Property Act, rules regarding the Transfer of Property Act, performance of contract. The tender of performance must be made at the proper time and place. And we are also going to discuss some case study along with the examples. So before starting this session, let's see the objectives of this Transfer of Property Act. To state the meaning of Transfer of Property Act, to know the various types of property transfer, to identify the responsibility of seller during the transfer of property under the Transfer of Property Act, to understand the duties of buyer during the transfer of property under the Transfer of Property Act, to acquire the rules related to the Transfer of Ownership Act. So students, in this Transfer of Property Act, we are going to discuss what is called property. Already under the Sale of Goods Act 1930, we have seen what is called goods, what are the different types of goods, how to be handled, all the things we have discussed in the Sale of Goods Act. Okay. If you want to view the Sale of Goods Act, please view the description box. I have given a link over there. You can see the Sale of Goods Act. See, in this topic, we are going to discuss how far the transfer of property is going to held. And at the time of transferring property, who are all responsible? Either seller or buyer, all the things we are going to discuss in detail. So this section 7 of the Transfer of Property Act lay down the rules, people who are legally eligible to transfer of property. Every person competent to contract and enter to transfer of property or authorized to dispose the transfer of property, not as his own, incompetent to transfer such property. But the minor, as well as who is insolvent and sound mind person, they could not able to enter in a contract of transfer of property. Properties that cannot be transferred under the Transfer of Property Act. In terms of immovable property, one cannot transfer a property that can expected to inherit in future, state the Transfer of Property Act. So already we have seen under the Sale of Goods Act, the Sale of Goods Act is applicable to the movable property, that to cash. Cash must considered for the Sale of Goods Act. So example, here I have given an example. Ram expects that his maternal uncle, who had no children of his own, would bequeath his property to him, and he transferred his right in the property to his son. The transaction would be held invalid. A leaser can also not transfer his right to re-entry into the leased property under the Transfer of the Property Act. So see the first example here. The Ram expert. Ram is a person who expert his maternal uncle. That means the Ram's uncle who do not have a child. So he expert that his uncle will transfer the property to his name. Okay. So it is not like valid one. It is an invalid one. Okay. Since he is not having some legal relationship. Okay. Next example, Ram released his plot to Mohan and put in a clause in the legal lease agreement that he would have the right to re-enter if the rent is not paid for over 3 months. Then he alone will have the right to do so. He cannot pause on his right to re-enter to say Ganesh is associate. What do you mean by this? For example, being a owner, if I'm leaving any tenant, if I am leaving my home for rental purpose for any tenant, contract, the transfer of ownership is held between myself and then the tenant. Whether he is going to pay rent or lease, that is secondary. It is the contract between myself and the tenant. He cannot able to transfer this property. This means he cannot able to transfer his, the property act to the somebody else. Okay. Here also the ownership is not transferred. Introduction. Under the Indian legal system, properties are divided into two categories, movable and immovable. The Transfer of Property Act 1882, which initiated in the year of July 1st, 1882, deals with the aspect of transfer of property between living beings. Okay, what does transfer means under the Transfer of Property Act? The term transfer includes transfer through sales, mortgage, lease, actionable claim, gift, or exchange. The Act does not cover transfer by the operation of law in form of inheritance, forfeiture, and insolvency, or sales through any execution of ticket. So here, the transfer includes only the sales, mortgage, lease, and actionable claim or gift exchange. It is not applicable for the insolvency. Types of property under the Transfer of Property Act: sales, lease, mortgage, exchange, gift, and actionable claims. So let's see some concept here. Transfer of property to an unborn child under the Transfer of Property Act. So students, please listen this. A person who is planning to bequeath his property to more generation than one will have to keep the provision of Transfer of Property Act in mind while doing so. This becomes imperative to avoid legal complication at a later stage. So what they are trying to say, whenever you are transferring your property from one person to another person, you have to remember certain points which is already framed and regulated and structured in the Transfer of Property Act in 1872. Okay, so we have to be clear with the terminology. We could able to get a help, then we should have a proper knowledge. In case if you would have not have a knowledge, then we can ask the lawyers or somebody who is expert in the particular field. We can have we can get advice from them. Okay, so we should be very clear with the Transfer of Property Act. Then only we should involve in the process of transferring our property from one person to another person. Under the provision made in section 13 and 14 of a Transfer Property Act, the transfer of property directly in favor of unborn child is prohibited. Okay, so usually we know the parent will be transferring their property to the children. Even the grandfather will be transferring the property to the grandchild. Okay, so this is possible, it is valid, but transferring property to the unborn child is not valid. It is a prohibited one. Okay, it is a prohibited. So we will see with help of one example. For this to happen, the person intending to make the transfer will first have to transfer in favor of a person who is alive on the date of transfer. For example, one grandfather is there. One grandfather name is, for example, Gopi. Okay, Gopi's son name is Kumar. Gopi, he would like to transfer his property to the grandchild, but the grandchild is yet to born because Mr. Kumar is recently got married. Okay, so in this case, the Gopi, the grandfather, he could not able to transfer his property to the unborn grandchild. So instead of that, he can transfer the property to his son Kumar. Once the baby born, the ownership might be transferred to the baby once he become a major. Okay, in such a way, the transfer of property can occur. See the example here. Suppose Ram transfer his property to his son Mohan and thereafter to his unborn grandchild. Here in this example, Ram is a grandfather and son is Mohan. Okay, so Ram, the grandfather, he would like to transfer his property to his grandchild. So in case he was not born before the death of the Ram, the transfer would not be valid. So usually whenever the grandfather wants to transfer the property to the grandchild, he has to wait till the baby born. Okay, once the baby born, then only he has to write transfer the property on the name of the baby, also nominating or making as a guardian of some person. Till he born, he should not able to transfer the property. That is the concept is about. Responsibility of the seller during the transfer of the property under the Transfer of Property Act. To disclose, now we are seeing the responsibility of the seller. Whenever seller wants to transfer the property, he wants to disclose the buyer any material defect in a property. For example, I am a seller. If I want to sell any kind of a property to so and so person, if the particular property has any defects or any kind of material defect or any kind of issue is there, I need to communicate to the buyer or customer in a proper way. Everything should be pre-informed. Okay, to provide to the buyer on his request for examination all document of the title regarding the property, as well as a seller, whenever I'm transferring goods to the buyer, I need to hand over all the documents whatever related to it. Okay, as well as I need to do the proper examination. I should allow the buyer to do a proper examination. To answer to the best of his information, all relevant questions put in by the buyer with respect to the property and the title. So whatever information I knows about the particular property, being a seller, I need to communicate to the buyer. To execute a proper convenience of the property when the buyer tends himself for execution of proper time and place, as well as when we are transferring the property to the buyer, we should ask the particular buyer about the time of registration and place and payment, or is there any kind of a commission, all the things to be clarified in the initial stage itself. Then to take as much care of property and all documents which are in his possession as an owner of a ordinary prudence would take a such property between the date of contract of sales and delivery of the property, as well as it is the responsibility of the seller to hold, to have all the proof, evidence, documents, whatever related to the particular property. So still, until I transfer the goods to the buyer, I should have all the positions of the property document. Okay, in case if the buyer have any kind of a doubt, then I should be in a position to clarify, to give the buyer position of the property. As once the buyer paid the full amount, then I need to hand over the portion of the property to the buyer to pay all the public charges and rent accrued with the respect of the property up to date of the sales. And in case if the particular property has some tax to be paid, or is there any kind of a GST or some other tax, home tax or water tax, electricity bill, anything to be paid, till the movement of goods from seller to the buyer, whatever taxes is levied, then it is a responsibility of the seller to settle down, to discharge all the encumbrance on the property then existing. That means if being a seller, I should make sure that there should not be any kind of a problem or difficulties to be faced by the buyer at the time of exchanging the goods from the seller to the buyer. Duties of the buyer during transfer of property under Transfer of Property Act: to disclose to the seller any fact about the property and which buyer is aware. So here, see, in previous slide, we have discussed what are the responsibility of the seller towards the Transfer of Property Act. Whereas in this slide, we are discussing what are the duties of the buyer during the transfer of property under the Transfer of Property Act. To disclose the seller any fact about the property of which buyer is aware. Sometimes, see, just like, for example, I want to buy one land. Okay, just like that, I will not buy. Even though a seller gives lot of information, the owner of the property give lot of information, or any broker of the land is giving lot of information, I will not believe everything. I will collect all the information, but side by side, I'm also will be collecting certain information about the property. I may have an inquiry with the neighbors or somebody else who knows about the site very well. I may ask some local, local advocate or local some that panchayat board who will be knowing about the property very well, right? So once I get all the information, if I'm suspect with any kind of information, if I'm aware about any kind of information about the property, then I should clarify with the particular seller immediately to pay the purchase money to the seller at the time and place of the compelling with the sales. Okay, now everything is done. So now in case if the transfer of ownership is going to transfer in the sense, I need to pay the amount whatever is I agreed to pay to the seller, and I need to follow the time and place what has been fixed for the transfer of property. To bear any loss arising from the destruction, injury, decrease in the value of the property not caused by the seller, where the ownership of the property has passed on to the buyer. So in case if there is any kind of a loss arises because of the destruction, injury or decrease in the value of the property caused by the seller. So here, once the ownership is transferred to the buyer, then he is responsible. Till the ownership is transferred, seller is responsible. We have to be clear with 2 points, students. Before the ownership is transferred, if the position of the goods and ownership is with the seller in the sense, he is responsible. Whereas the ownership is transferred, the position of the goods also is transferred to the buyer in the sense, whatever may be the problem, whatever may be the deficiencies or whatever it is, it has to be borne by the buyer only. To pay all the public charges and rent, which may become payable on the property, the principal monies due on the encumbrance subject to the property sold. Already we have seen this. Next, rules regarding transfer of property. See, if you take a transfer of property act, this is a very much important question to be asked during your examination, as well as this topic is also coming under the sale of goods act, but this is a some common topic which has to be coming under the transfer of property act. That's the reason we are keeping here. So rules related to the transfer of property act, there are 3 rules. Number 1, when the transfer of property ownership goods take place from the seller to the buyer, for this purpose we have a 2 headings. One is specific goods and ascertained goods. What is called specific goods? Already told you under the sale of goods act, right? Specific goods in the sense when the buyer knows what kind of a goods he wants. For example, I told in the sale of goods act, for example, one person, one buyer is visiting some grocery shop and he's asking Good Day biscuit. So in this example, he's specifying the brand of the biscuit and asking. That is called specific goods. If it is available, the seller will be giving you. Ascertained goods in the sense where sometime all the goods, whatever the buyer is asking, the similar type of a goods will be displayed. Sometime what will happen? Sometime the buyer once he wants to decide to buy for particular brand of a goods. For example, he wants Good Day biscuit. He paid the amount, but suddenly he saw some other brand. So he's the same for similar amount, whatever biscuit is available. For example, Oreo biscuit is available. That time he's asking the seller to give a Oreo biscuit. So here ascertained in the sense everything separated. All the goods have been separated as per its specification. That is called ascertained. Unascertained in the sense where the goods has not separated. All the goods are in as a bulk. There is no any kind of a specification as done so far. Then future goods, that is also is there. Let's see one by one. So there are around 6 rules to be followed at the time of transferring of any kind of a property in goods. Keep it remember, rules of transfer of property in goods, section 25, 1930. This is coming under sale of goods at 1930. So again, I'm telling you, since the Transfer of Property Act is a common topic, so that I brought this concept under this transfer of property. That's a separate heading, as a separate video. Okay, number 1, in case of sale of specific goods. So in case of sale of specific goods, already I told you what is called specific goods, section 20. So first let us see the case study, then I will explain you what is that. So this is a case study between Badri Prasad versus state of Madhya Pradesh. So Badri Prasad, the merchant, has selected some standing trees in Madhya Pradesh, in the forest department, to do some transfer. But before the ownership transfer, the selected tree were destroyed in a fire accident in the forest. So now tell me who will be the responsible for this? So obviously the Madhya Pradesh, the state of Madhya Pradesh is responsible. Why? Because the transfer of ownership is not done. I hope so you can understand. So in case of sale of specific goods, even though the buyer or customer specifying the goods, what he would like to buy, he has not paid the money. Just he has selected the goods, whatever he wants to buy. He has not given any kind of this one, some advance or something. He has not done anything, but he has specified that I need these goods. Okay, but before the date of delivery, before making a payment, if anything happens to the particular goods, then who is responsible? The seller. Why? Because the ownership is not transferred here. The ownership is held up with the seller only. Rule number 2. In case of sale of ascertained goods, identify and separately kept. So here, this particular the buyer, what they have done, they separated the goods separately. They identified the goods and kept it separately. Okay, they have paid some advance or something else. Okay, so now the seller is telling, you have paid the goods, right? You have paid the amount for the goods, you can take it. But here the buyer is requesting the seller, please give me some time, I will come and take. But he has paid the amount. The bill also has prepared. In this situation, what will happen? If anything happens to the particular product, who is responsible? The buyer. Why? Because the transfer of ownership is done. Even though the position of the goods is held up with the seller, the ownership is transferred. Okay, see some, I have given one case study here. Tarly versus Baxter. So Tarly, he's a purchaser. Then the Baxter is a hay stock, dry grass seller. Okay, so you know what is called dry grass? White coal. In Tamil they used to say white coal kuvial. Okay, so what happened? The Tarly, the purchaser, has separately identified and kept a hay stock which need to transfer. But before the delivery of a selected goods, it was destroyed in a fire. So what is the solution given in this case? The purchaser is responsible since it is held under the ascertained goods. Okay, ascertained goods. Ascertained in the sense, as a buyer, they approach the seller, they identified the goods what he wants to buy, he separated, he has paid the money. Okay, the ownership is transferred, but the position of the goods is held up with the seller. Seller has given clear instruction already, since you have paid the money, take your goods. But due to the requisition of the buyer, here the goods has been kept it for the seller custody. If anything happens, who is responsible? The buyer, not a seller. Here, in case of a sale of unascertained goods, not identified or not separately kept. So here, see this, the goods are mixed. What you mean unascertained? The goods are mixed and not identified or not selected separately. But the purchaser, hence the seller, is responsible if there is any kind of a damages in goods before the delivery. For example, one buyer visited my shop. He has given order. Tomorrow there is a function at my home. So I need, there is a birthday party in my home tomorrow. So I need around just 10 liters of cool drinks and 100 packets of biscuits, like that he has given order, but he has not specified any brand of the cool drink or any brand of the biscuit. He just generally he has quoted the product. He has not ascertained. That means he has not identified or separately kept. He has given order. That's it. The next day before delivery, if anything happens to the goods, who is responsible? The seller, not the buyer, because the buyer has not identified or ascertained the goods. Just he has given a general information, general order. In this case, so if anything happens to the goods, who is responsible? The seller. Where, because here ownership is not transferred, it is held up with the seller. So you should understand, whenever if any kind of a case study is given, to know who is responsible for the loss arises at the time of transfer of property, you should read the case study twice or thrice, should understand whether the ownership is transferred from the seller to the buyer or not. In case if the ownership is also transferred, then also you should identify again whether the possession of the goods is with whom. For what purpose the possession of the goods is not transferred, whether it's based on the buyer request or seller, whatever it is, you should understand. So before reading any kind of, before giving solution to the case study or before answering for any kind of a case study, first try to read the case study first and relate the case study along with our concept. You should thorough with the concept. Always we should know the concept, the theories, which is already developed. Once we know, once we have a knowledge about the theories and concept which is already developed, then we should correlate these theories as well as this concept with a given case study. We should understand which concept or which theory is associated with the particular case study. Once we trace it out, then we should know what are the concept, what is the theory, what are the points is given under particular theory or concept, whatever it is. Then we have to try to solve the case study. This is a thing, in such a way you have to solve the case study. Rules of transfer of property in Goods Act. Rule number 4, intention of the parties. So intention of the parties. See the example first. So Mayors, this is a case study between Mayors versus Apply Buy. Mayors, the buyer, versus Baxter, the merchant, seller of a machine. Okay. So Mayors, the buyer, want to buy a machine from the seller, but the seller said that the machine is not in a good condition. It is under the process of repair. It means that he wants to buy some second-hand machine. Okay. So buyer, who is a buyer? The mayor. Mayor is a buyer. He wants to buy some second-hand machine. So he's approaching the seller, Baxter. Okay. The Baxter is saying clearly to the buyer that, sir, this machine is not in a good condition. It has to be repaired. Some modifications, some moderation to be done. The buyer agreed it. The buyer agreed. It's okay, sir. I like this machine. Since my budget is associated with the second-hand machine only. So I am agree with this. So here the seller has given a clear communication and information about the particular product. Okay. Then also the buyer agreed to buy it. Okay. He has received the money. So buyer agreed to receive the machine. He has machine and the repair of the goods before the delivery date. So they have fixed up the delivery date. He said, okay, sir, I've delivered the goods on so and so date. I will do repair. I will start to do a repair. Before the delivery date of the selected goods, it was destroyed due to some fire accident or some mechanical error or something else during the time of repairing condition. So who is responsible for this? So in this situation, we have to see the ownership is held up with the seller. The portion of the goods is held up with the seller. But the buyer agreed the ownership. The buyer agreed to take up the property. So in this case, the court of law held that the solution is given like this. The court of law held that the seller is responsible because there is an agreement between both of them, but ownership is not transferred with the seller only. Before the goods ownership is transferred, the machine got destroyed under the process of repair of machine. Do you understand? Even though the buyer is accepted to agree or accepted or agree to get some second-hand machine, even though it carries some default or some fault in the machine, before it delivered to the, before the ownership is transferred to the buyer, some fire accident, something happens to the goods in the sense, who is responsible? The seller. Why? Because the ownership is with the seller only. In case of goods delivered to your carrier, the buyer is responsible if there is any damages in the goods before the delivery at the time of transaction mode, because bill or receipt is already prepared on the name of the buyer. For example, see this. So I'm a seller. Okay, I'm a seller. One person from Thuthukudi, he is visiting my shop. He wants to start. He has ordered some goods. He has given a money. The receipt, the bill copy, voucher, everything is ready. Okay, the bill copy, everything is ready. Receipt, everything is ready on behalf of the buyer name. Then I said, okay, sir, delivery is not possible. You have to take it your own delivery. Then he said, okay, sir, fine. Then now the goods is in transition mode. I hand over the goods to the carrier person as per the request. Please make a note of it. As per the request of the customer, I'm just transferring the goods to the buyer by the carrier, by the intermediate. Before reaching the goods to the customer hand in a Tutukudi, the particular container or some other, the goods got destroyed due to some accident. Unfortunately, the particular vehicle which carries the good met an accident. The goods also got damaged. So in this case, who is responsible? The seller or buyer? Here, the seller is not responsible, buyer only responsible. Why? Because the ownership is transferred to the buyer. The bill and the bill copy is already created on the name of the buyer. The buyer only requested the seller to transfer the goods. Even though seller has given clear communication to the buyer, sir, selling the goods only is our part. Transferring is to your own risk. He has given a word here. Then also he has accepted it and he approached the seller to transfer the goods. So in this case, who is responsible? The buyer, not the seller. Goods sales on sales. Goods sales on sales are return basis. So what is this? Sometimes the sellers, what they will do, they will sell the product to the buyer. If the buyer, they do not accept it, they will accept it. They will accept the return and sell it to the another person. That is called goods sale on sales or return basis. Let's see with one example. Let's see with one case study. This is a case study in between Eltic and versus Barry's. Eltic versus Barry. So Eltic, seller of a horse, versus Barry's, the representative to sell horse. Okay. So Eltic, the seller, handed over his horse to his representative to Barry's for sale purpose. But after some time, the representative was not able to sell the horse in a given fixed period of time. So what happened? Before, he was trying to hand over the horse to the seller itself. Before handovering the particular horse to the seller, the horse died. The horse is no more. Now, who is responsible? The seller or his representative? Who is responsible? So since this contract is created based on the goods sales on sales return basis. If the goods is not returned, if the goods is not sold, then automatically it is the duty of the seller to take a return back of the goods. In this case, the ownership is not transferred. Only the position of the goods is transferred to the representative of the seller. You can able to understand, right? So Eltic is the seller of the horse. He handed over horse to one of his representative is called Barry's. Okay, so he has given a 1 month of time. He has given a position of the goods. That means he has given a horse to the representative, but not a ownership of the goods. He was trying to sell a horse. The representative is trying to sell a horse. He could not able to complete this particular contract. And before date, what happened? He was trying to return back the horse to the seller, but before the date, the horse dies. Who is responsible? Not a representative, he is seller. Why? Because the ownership is not transferred to the representative. That's all. These are all the important rules to be followed at the time of delivery of any kind of a property in terms of goods. So we can see the small recap. So in case of sale of specific goods, in the sense, ultimately who is responsible? The seller is responsible. Okay, because here ownership is not transferred. In case of sale of ascertained goods in the sense, here the buyer is responsible. Why? Because the goods are separated, identified and separately kept, and the amount also paid, the ownership transferred. If anything happens to the product, buyer only responsible. In case of sale of unascertained goods, here the goods is not identified as separated. Generally, order has taken from the seller. He has not paid the money. So if anything happens, who is responsible? The seller is only responsible, not a buyer. Intention of the parties depends upon the intention of the party. If the the seller or buyer, if they intentionally they enter in a contract, but due to some situation, sometime the responsibility may lies on either seller or buyer. In case of goods delivered to the carrier, as I told you that in case if you are selling, if you are handovering goods to the carrier, if the ownership is transferred to the buyer, then buyer is responsible. Whereas if the ownership is not transferred to the buyer, then who is responsible? The buyer only, the seller only is responsible. Goods sale on sale basis in this case. So it depends. The seller intentionally he is selling the goods. In case if the buyer is not ready to accept it, he is ready to accept. So it depends upon the situation also, we have to handle this kind of a case study. So next, deliverable state. The specific or ascertained goods must be deliverable state, which means the state in which the buyer cannot refuse the delivery of the goods bound to take the delivery. For example, polished furniture is ready for the purchase at the showroom. Here, furniture is in a deliverable state. Okay, rules. The ownership property in goods said to be transferred immediately from the seller to the buyer. Do you understand? For example, I am a seller. Okay, one person is visiting my shop. I am having a furniture shop. One person is visiting my shop. One person is visiting shop. So what you can do, you are allowing the person, the buyer is the buyer is seeing all the furnitures, whatever is available. He has choose one furniture which is in a mode of delivery. That means the furniture is ready to deliver. It is in a deliverable state. He has paid the money, in the sense immediately the ownership can be transferred. That is called deliverable state. Then non-deliverable state. What is called non-deliverable state? When the goods are specific or ascertained are not in a deliverable state. That means when the goods is required some what to be added or it's to be in a mode to finish it, then what to be done? Then you can ask, it can be considered as a agreement to sales. Okay, example, polishing of furniture is required before the delivery of goods. So here goods will be deliverable state once the polishing is completed. So example, rules is given here. The ownership and property goods is said to be transferred from the seller to the buyer. Once the goods are in a deliverable state, a notice for the same is given by the seller to the buyer. Till the time is not in a deliverable state, the ownership lies with the seller only. The next one is price, weight, measurement of the goods yet to be determined. Sometime if the customer or buyer is not determining the price or weight or quantity or quality of the goods, in the sense, the seller has to wait till the clear instructions given by the buyer. Once he received the clear instruction by the buyer, then only he can deliver the goods. So it is also called as an agreement to sale. Okay. So here the ownership remains with the seller. Where the goods are delivered on approval basis rule. What do you mean with this? Where the goods are deliverable on approval basis. When buyer gives his approval or acceptance to the seller, does any other act of giving approval to the transaction like consumer goods, resale goods, third party, etc. When a buyer does not give his approval or acceptance to the seller, but retain the goods without giving a notice of rejection beyond the time fixed for the return, if no time is fixed. So we have to see the customer. That means we have to get a clear information from the customer. Then only we have to consider the mode of delivery. So already we have seen what is called unascertained goods. Unascertained goods needs to be ascertained. That means if the goods are in a general term, you should get a clear information from the customer or what kind of a goods they want, what is the brand name, how much quantity they want. Likewise, you have to get a clear instruction. Then you have to make them to pay for a product. Then only the ownership will be transferred from the seller to the buyer. So some of the exemptions to be given. What are the exemptions? That exemption is called as nemo dat quod non habet. That nemo dat quod non habet means the seller should have the ownership of the goods in order to sell them to the buyer. But there are few exemptions to it, which means even non-owner can sell even if they don't have the ownership of the goods. So what do you mean with this? So usually as per the Sale of Goods Act and Transfer of Property Act, the owner of the goods, the seller of the goods, he has to transfer the goods. But sometimes he can transfer the goods by somebody else. Let's see who are they. First one, sales by Estoppel. Already we have seen under the this one contract act, Indian Contract Act 1872. Estoppel means it's based on some condition. In case if the goods carry some condition, if the customer is giving some condition, or if the seller is giving some condition. So based on the condition, the goods has to be transferred. Sales by merchandise agent. Sometime I'm having a head office and in Chennai. One person from Trichy is giving an order. I am also having a warehouse nearby Trichy in the sense I can appoint one of my agent to deliver the goods from my warehouse. So that is called sales by agent. So in this topic, we are seeing who are the parties can do the transfer of property. So usually the transfer of property can be done either by the owner of the goods or seller. Sometimes the agent of the particular seller also can able to do the transfer of property. Then sales by joint owner. In case if the particular business is framed with help of a partnership, then the particular person, either the seller or some other person who is associated a business, can transfer the goods. Sales by a person in the possession of a goods under the voidable contract. In case if I'm having since I'm having a head office I'm having only corporate office in Chennai. My all goods are in warehouse somewhere, some other place, maybe it is in a Tanjavur somewhere in the sense. I can assign somebody else to transfer a goods. Okay. Next, sales by seller in the possession of the goods after the sales. So sometime I will be getting an order from the buyer. Once I get an order from the buyer, I can instruct somebody else. I mean, my merchandise agent and somebody else to transfer the goods. Sales by buyer before the transfer of ownership. Sometimes, for example, A has not sold the goods to B, but only the delivery the goods to B. That means only the portion of the goods is transferred. So here, this does not make a B a buyer. A is a seller. Do you understand? Sometimes the delivery of a goods can be done. The delivery of the goods might have completed, but the ownership is yet to complete. In this case, the ownership is still liable with whom? With the owner only. I mean, it's about the seller. For example, you can take a Bailey concept or some other concepts, which already we have seen in the last classes. So there are some exemption for this. So finder of the goods already we have seen. The person who is finding the goods, they have to hand over to the owner of the goods. Okay, even we have seen the partner bond concept. So what is called performance of contract? So performance of contract, already I told you, as per the Indian Contract Act 1872, an offer is an expression of willingness made by a person to do or abstain from doing any act or omission with a view to obtaining assent of the person to whom such offer are to be made. That means performance means as a seller, I need to specify. It is my responsibility to ask the buyer to specify the time and place where I need to perform the contract. Do you understand? In case if the buyer is not giving any clear instruction, like in which address I need to deliver the goods, at what time I need to deliver the goods, in the sense, I can follow the general rules and regulation that business time, business working hours, Monday to Friday, from morning 8 to 10. So like that, we need to follow some rules and regulation while we are transferring goods from one person to another person. So here some case studies also given. So in this Transfer of Property Act, we have seen the clear information about how the transfer of property to be done, who is responsible in case if there is any kind of a loss arises. Okay, what are the time, what are the main responsibility of the buyer and seller at the time of delivering a product, and then at last we have seen some of the exemption case and who has to perform the Transfer of Property Act, then at what time we have to perform the contract. Thank you.